Domain Tools helps security analysts turn threat data into threat intelligence. They take indicators from your network, including domains and IP addresses, and connect them with nearly every active domain on the internet. Those connections drive risk assessments, help profile attackers, guide online fraud investigations, and map cyber activity to attacker infrastructure. Fortune 1000 companies, global government agencies, and leading security solutions vendors use the Domain Tools platform as a critical ingredient in their threat investigations and proactive defenses. For more information, visit securityweekly.com/domain tools. Today's determined attackers easily bypass even the most advanced network defenses. Trying to ramp up staff to detect their backdoors can cost thousands of dollars and take months, even years. With Active Countermeasures AI Hunter, we enable junior analysts to detect even the most advanced backdoors in a matter of hours. Sign up for a demo and purchase our product today by visiting activecountermeasures.com/BSW. Active Countermeasures. Make every analyst a hunter.
All right, we're back. And we convinced Shawn to stay. He brought up that little bit before about privilege, and it's something that you've asked about. So one of the things that you're going to start seeing is, we didn't just shift to Mondays. We didn't just shift to Business Security Weekly from Startup Security Weekly, because as you see, we still cover innovation, and in segment 3, we got a lot of updates for you this week. What we're really looking at, though, is how are we helping the needs of our partners in the industry? How are we helping those of us in the community make these decisions better? And so one of the things is, when you write in and you've got ideas for suggestions on what you want to see, I'm going to try on a monthly basis to give answers. And one of the things that's come up, and it's interesting, timing-wise, it just worked out that a bunch of folks have written in and asked about attorney-client privilege. And is that a good strategy or not? Does that help us in security or not? And I thought, well, perfect timing. So we're going to do a segment on that. But just quick reminder of our on-demand material. One of the things that I love about the Security Weekly Network is the ability to create content, have great interviews, talk with people, put on fun webinars that don't do any of the things that we typically talk about that are annoying. And we now have it as on-demand material. You can check that out at securityweekly.com/on-demand. And there's a whole bunch of different stuff up, including some old webcasts, some new content. Take a look at it. And at least for me, my take, I'm always interested in what you think and what we could do to make stuff better and what would really help you. So if you feed that in, you'll do that. And let me get some advice here from Shawn Tuma. So Shawn, at the end of the last segment, you talked a little bit about the concept of privilege, and we've kind of minimized it. So we could talk about it here a little bit. I think most of us at some point have watched TV, so we have this notion of what attorney-client privilege is. But if you don't mind, just back up for a second and let us know a little bit about attorney-client privilege, and then why it's interesting. Why is that coming up in security more in the last couple of years?
Well, Michael, the reason it's coming up more, to be a little bit cynical, is because many of us attorneys are trying to find a role for ourselves in security, and we're trying to figure out how to explain our role. And the easiest way is to say, aha, we've got this thing called a privilege, and that privilege keeps us from having to disclose anything, and therefore we can protect all of your work. And all you have to do is hire us and pay us, and we sign on the dotted line, and now you're protected. It's like, we carry around the fairy godmother's little magic wand and go ding, 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 and privilege everything. And then when bad things happen and people ask you about what you knew or how you got there, you say, well, it's all privileged. I don't have to tell you. That's false. That's not how this works. The attorney-client privilege is one of the most oldest and sacred privileges recognized by the law. And what it says is, when a client has a confidential communication with an attorney for the purpose of rendering or obtaining legal advice, they do not have to disclose the contents of that communication. They can claim a privilege on it, that it does not have to be disclosed. It does not have to be disclosed, and it's off limits. And the purpose of that is to protect the sanctity of that relationship and encourage clients to be honest and truthful with their attorneys, so that attorneys can do a good job and we can, have a more efficient legal system. Now, there's a couple of things in there that I want to unpackage. One is it has to be a communication. Okay, you can protect the contents of a communication. That communication does not mean you can shield the facts of what have happened. Okay? The facts are usually what we're most interested in. And so, there's a little bit of misconception there when people think all I have to do is hire an attorney and everything's protected. No, the communications about what took place are protected, but the facts of what happened or didn't happen are generally not protected. And then the other thing is that it has to be between a client and the attorney, or basically representatives of either of them. And then the other is it has to be for the purpose of obtaining legal advice. Not business advice, not cybersecurity advice. There's no cybersecurity privilege out there. And so we have to structure things in a way to give us the best argument for that privilege. And I don't mean to dismiss the privilege as a whole. It's very powerful, and there's a good purpose and a good use for it many times. But it's not this little magic talisman that we like to say it is, because at the end of the day, do you know who determines whether a privilege is valid or not? A judge. A judge sitting on the other side of the bench who may have had a good day or a bad day, and they may not like what you have to say, and boom, it's not privileged, move forward. So really the lessons that we take from that is, let's do everything we can to prepare properly to have a privilege, but let's conduct ourselves in a manner so that if it's not there at the end of the day, we're not shooting ourselves in the foot.
There's so much there. I love how you unpack that. No, it's like
I'm sorry.
You and I have done this. No, we've done this a lot. Where my brain's going a lot of different ways, and this is where prep comes back in. So as all these other questions, and by the way, so Shawn, if people have questions on Twitter, you're Shawn, SHAWNE Tuma, right? At Shawn E Tuma, and they can get you. Is Twitter the best spot you think for people to find you, or where else can they find you?
Twitter's a good spot. They can email me, shawn.tuma@solidcounsel.com. Connect with me on LinkedIn, wherever else, I'm out there all over the place.
Yeah, and if you can connect to me, I can always connect you to Shawn, and you'll see the two of us interact quite frequently online. And the reason I'm bringing that up is because if you've got questions about this as you're watching it, you can pound them in. I know Shawn will get answers, and we can either answer them in social media. I can do an update in the future, or of course, it seems like we'll be happy to bring Shawn back as long as he keeps coming back. So give me some examples on where this concept works, because and we'll come back and we'll talk at the end about preparing for that privilege to be decided it doesn't exist. But where then conceptually, when I hear somebody say, oh, well, you get an attorney for that and you get privilege, and that's a great concept. So tell me where this works. What's a construct where you think this is successful?
Well, in my view, we don't have a lot of cases out there dealing with attorney-client privilege in cyber at all, really. But in the pre-breach context, we're really kind of flying blind a little bit because we don't have much case law at all in the pre-breach context to talk about the risk management side. We do have a few cases in the post-breach incident response context that we can talk about in a little bit. But so a lot of this is me looking at my understanding of this and understanding the two fields and figuring out how to meld them together. Because remember that key part I said, it has to be for the rendering of legal advice. So let's take a pre-breach context and say, I want to develop a risk management program, and I want to hire an attorney to help lead this risk management program because I want them to help our company understand our legal and regulatory liability that we're facing if something goes wrong. How defensible are we from a legal and regulatory liability standpoint? Okay. That's something perfectly within the wheelhouse of an attorney. So what do? What I do is you hire me first, or anyone that's doing this, and then we retain the consultants that we need to help gather and provide us with the information that we need to render back to you the legal advice on how defensible are you. And we then must stay integrally involved in that process because remember, we're gathering and providing information for the rendition of legal advice here. That's all an attorney can privilege is their legal advice. or those communications. And so what we do is we have the third parties, the vendors, the consultants, then, if you will, the people doing the risk security assessments, the pen testing, go out, do what they can do, report back to us as legal counsel, and then we are the filter that sifts all that information up and then produces something to the client that says, here is my advice in my assessment of where you stand from a legal and regulatory standpoint. Okay, that right there should be privileged as long as I'm sticking within the guardrails of being a lawyer in a field of law. What's not privileged?
Go ahead.
Okay, what's not privileged here is what did they find? What did that security assessment discover, if it's a known vulnerability in the company? Or what did they, what weaknesses did the company have that are out there? That's a fact. Those are facts. The attorney-client privilege does not shield facts. Now,
okay, so
hopefully,
well, go ahead, because you're
hopefully
answering the question.
What you've done is you haven't put anything in writing. You haven't prepared any reports of these vulnerabilities. In an ideal world, and everything's been communicated to me, the attorney, verbally, and then I prepare a report that I say is attorney-client privileged and and provide that to the company. That way, we don't have a paper trail of things to evidence those facts that could then be discovered in the future. Now, that doesn't happen often. Usually people want that paper trail. So that increases the risks here. Everything that's being put in writing that reveals facts that could be discovered down the road. So my point, Michael, this is not an easy process to try and do it right if we want to protect it.
Yeah, so I just want to push on a little bit, try to see if I can get my head wrapped around it, because you in that second part, where you said it doesn't work so well, I've heard people in the past say, well, retain the attorney then retains the experts, and none of that matters. And they always feel like it's like so I don't have to claim I knew about it because it was my attorney and they were giving me advice. And what you're saying is, no, that's a fact. So when you say that, no, because that's a fact, and they're different than the communications about the facts, if under your role in offering legal advice to help make sure of defensibility, et cetera, relative to security, if you hire a company to do a pen test or to do some sort of an assessment, and as part of that they produce a written report for you, then if for some reason this went to a court case, the opposing counsel could then request that becomes something discoverable to them?
They would certainly request it, and then we would resist it by saying, no, that's subject to the attorney-client privilege because I was preparing, my analysis. I hired them as my consultant, and they are what we would call non-testifying experts, or they're an agent of mine in gathering and preparing this information. And so we would try everything we have with that to protect it. And we would probably have a fair amount of success with that, but it certainly wouldn't be guaranteed.
Okay. And so what you're then saying is, for this to work, if those things
didn't exist, then there's no way they could request production of them. That's all I'm saying. The less you document and put in writing for privilege purposes is the better. But here's where it all gets thrown out the window, Michael. When you have an incident, the most effective thing you can do is show your work to the regulators in court cases, to show your diligence. Showing your work requires showing all of the things you've done to be diligent and reasonable. That requires producing a lot of this stuff, okay? And you can't use the privilege as a sword on one hand and a shield on the other. You got to pick one side. And so that's why I'm saying it all sounds great to talk about the privilege, and we need to do everything we can for it. But at the end of the day, don't put all your eggs in that privilege basket by allowing people to communicate a lot of things that should never go in writing, thinking that they're going to be off limits because it's not guaranteed.
That's a great point. And I want to then connect this back to something that you said in the last segment, where you said, we're talking about third-party risk management. We're talking about the legal case for cyber risk management, looking at overall. And one of the things you talked about was there's this expectation that you know about the information that you have. And we candidly talked about the challenges that there are for everybody in that whole process. But then what I'm almost picking up from you here too is, as an attorney, you're entitled, if you're properly retained in order to give advice on defensibility relative to these issues and posture, et cetera, then you do need to go gather some information, and you want as accurate and detailed as your time frame, budget, and needs allow. And so if they work as your agent, they can gather that information and that informs you. And the idea then for that to be covered under some sort of a privilege is that you're saying, in order for me to provide them competent counsel, competent advice, I need to have a pretty accurate understanding. And in order to do that, I need it independently verified by these third parties. I have expertise in that. And now with that information in hand, I can render proper advice to them. Therefore, it's privileged. And then somebody could argue back, they're facts, and the facts are discoverable. And that's the stuff that gets settled out in court. But it's still going to come back to the things that I should or shouldn't have known. So fundamentally, whether it's covered under privilege or not, there's not really an excuse to just tinfoil hat it or ostrich and dig your head in the sand and say, la, 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 I don't know about it, therefore I'm not obligated to do anything about it. You're kind of, I know I covered 3 areas. So we can finish, right? The obligation, like what you're saying, whether privilege works or not, is not a reason for somebody to avoid getting the information. If they work with an attorney in a qualified way, it might be privileged. But even if it's not necessarily privileged, there's a growing expectation that you would have this information as a company anyway. Does that sound
that's
like
right.
the correct summary?
Perfect. Yeah, you nailed it. I mean, think of your PCI assessments that you have to go through. You've got to do that no matter what. Okay, right. Claiming I did that for an attorney to render legal advice, the courts might not buy that, and sophisticated counsel wouldn't fall for that argument. But let's say you do your PCI assessments on one hand, but you hire your attorney to do this process, and they engage someone to do it separately, different provider, different purpose. Then you have a much better chance of making that argument. And the other thing here that people have to know is simply slapping the name attorney-client privilege on this is not going to get you very far, because courts look at the substance of what the legal counsel's doing, and they have to be involved in it. And if you're not going to have them involved in it, just putting their name on it's not going to do much.
So that's interesting too. So when the court goes and they look at privilege, and maybe I've watched a few too many police procedurals lately, there's somebody then, to your point, if it's documented, they're going to have a record of it, and they get to look at it. So the fact that it's privileged or not speaks more to not whether or not it can be discovered, it's whether or not it's relevant in the case, or is there an element of discovery involved in it too?
Well, when you claim a privilege over information, and there's a difference also between something called the attorney-client privilege and something called the work product privilege. They protect different things. Okay, work product comes in when you anticipate you're going to be in litigation. So post-breach, target, we know we're going to get sued over this. Let's start preparing our work product as well. That's a different issue, but they're twins basically. With your attorney-client privilege, you have to make sure that it's the communications, that they're for the rendering of legal advice, and from there, you're really just, I mean, I don't even know where I was going with that.
Well, it's okay. It's a complex issue. And so I'm really appreciating the opportunity to dive into this. One of the things I've always enjoyed, Shawn, about talking with you is that when we look at these cases and I ask about it, you've gone back and you've looked at the intent behind them. And then what we're seeing is thoughtful judges, and enough case law bubbles up. People look at the intent and they look at all of the branches of it and all of the opinions to try to come to what's prevailing. And I think this is one of those things where there's still concern in the security industry that the information that we have, if discovered, could be problematic, either for attackers or, I guess, as you're pointing out now, potentially if we have to defend ourselves in a criminal or civil suit relative to what obligations we did or didn't have. And
and you reminded me, Michael. Now I remember what I was going to say. Whenever you claim a privilege, the other side says you have to prove it. You have the burden of establishing it. So we have to prepare a log, what we call a privilege log, and identify the communication and state why it is privileged. And then if the court doesn't buy it at that point, they can do something called an in-camera review, where they actually go in the court, the judge looks at the substance of the material without revealing it to the other side and says, do I think this is truly a privileged confidential communication for the purpose of obtaining legal advice? Or do I think this is something the lawyer is just guiding on as a business business issue and just slapping their name on it? And so, like you said just now, we dig into the substance, and it has to be real to meet this criteria.
Maybe a little too much in the weeds, but if we get to the point where the judge starts to do the review, I mean, in your experience, and I'm guessing this doesn't happen that frequently, but are they keeping score? Like, are they going to say, okay, there were 12 messages, I'm going to read all 12, 6 of them were valid, they stay, these 6 weren't, I'll kick them out? Or is it kind of a all or nothing? Like, wow, 75% of this was all pure crap. All the privilege is gone? How does that work?
Well, that's a great point, because technically they're supposed to go through and look at each communication and determine each one on its merits of privileged or not. But look, judges are human, and they get tired of people wasting their time. And so if they look and they see someone has 12 claims of privilege and the first 10 are BS, and there's no way it's a privileged communication, when they get to the 11th and the 12th one, they probably are, a bit influenced and seeing that the attorney probably doesn't know what they're talking about, or that this is a sham, and it's very likely to impact that. So, use discretion and don't go overboard with this, and you have a much better chance of having it stick where it really matters.
So let's stick with the pre-breach context for a second. So is this an advantage based on all the nuances that we've talked about? I'm trying to just look at the same thing from a slightly different angle, Shawn. I'm a security leader today. And in the first segment, I said, hey, what should I go talk to my legal counsel about? Is this a conversation I have with them to say, hey, I want to make sure, right? Because I'm guessing the way I'd have to set this up is that we're legally defensible, and I'd love to confer with someone because in order to have the attorney-client privilege, inside counsel would need to retain an outside counsel like you or someone with that experience. Is that correct?
Well, there is a privilege that goes with in-house counsel as well over internal matters, and it theoretically it is effective for things of this matter, but it becomes much more blurred than what we've already talked about, okay, which is clear as mud, right?
Yeah, I was gonna say.
It becomes much more blurred when it's in-house counsel trying to invoke their own privilege. So I strongly recommend, if privilege is important to you, number one, you definitely should hire outside counsel. But number two, the question you ask, Michael, is, if you're the security leader, is you go and you talk to that attorney and say, look, I'm interested in this thing I've been hearing about called attorney-client privilege. How does that impact this? And if they tell you, oh, yeah, don't worry, hire me, and we're good, nothing ever's going to come out, then that may be an indication to you that they don't really understand all the nuances here that come along, as well as the fact you can never guarantee privilege. It's something a judge has to decide. And so if they tell you it depends, that might be the best answer of all, then ask them, how do we go about structuring our engagement in the best way possible to maximize our opportunity to have a privilege if we decide to use it? And that's really what we're shooting for here.
No, that makes a lot of sense. And so the use I'm kind of thinking about in my head is that I'd want to go to my counsel or my internal counsel, and I appreciate in smaller companies you're going to be sensitive to what that might cost and how your billing arrangements are set up. But let's say you're in the situation where this is either important to you or you've got the opportunity to go have that conversation. Shawn, it sounds like, I might say something along the lines of, I know in compliance I have the ability to comply, to demonstrate my compliance, or to make the case why I didn't need to comply. I'd really like to look at our legal defensibility options on this. And in order to do that, whether it's in-house or outside counsel or however they want to work it, there might be an opportunity there to really look at that from your current state, some different options. That's the type of legal advice that might make for a really good conversation.
That is. Right? I mean, that's something that, the facts that are discovered during the compliance process wouldn't necessarily be protected. But the process of analyzing that and determining what you need to do and what your requirements are and what you should put in writing or shouldn't put in writing, many of those things may be privileged. But Michael, let me give you an example of a situation I've been asked about by a potential client that really frames this. They were going through engaging cyber insurance, and they wanted help with cyber insurance. And so they said, if we were to hire you and you hired a vendor to go out and do a security assessment, if something was discovered, would we have to disclose it on our insurance application, or could we say, oh, no, it's privileged? And I said, there's not even an issue there. It's a fact. If you discover something and you're filling out an insurance application, I don't care who discovered it or what the context was. You have to be honest and truthful, or you're voiding your insurance. Of course, you have to disclose that. That privilege doesn't protect the existence of a fact. So let's take it a step further and say we have a security assessment performed, and I'm able to keep that assessment that's reduced to writing from being produced in court or to the other party. But then they put my client under oath and in a deposition, and the attorney knows what a security assessment looks like, and they start walking down the questions, and they say, were any vulnerabilities discovered during the security assessment? All right, the document's privileged. We've been able to protect that. But they can't lie in the deposition. They can't even say, no, that's privilege, because it's just a fact. Were there anything discovered? Were there any vulnerabilities? That's a fact. And you can ask those kind of questions, and you can't shield that with some, privilege over the communications about that.
But what does get privileged is perhaps the document. But certainly then if we have a discussion of, gosh, we're going to need to do this, but it looks like most people take a year to remediate that. So as long as we get it done in a year, we might have a legal case. Like, that's the kind of conversation that fundamentally, and I think a lot of times in security, we don't like it. We like to look at it and go, I found a problem, we're going to go fix it. But you don't have budget for that. Don't care. Give me the budget. But you don't have the manpower. It's going to create bigger. Nope, want to do it. And what we're saying is, if we're looking at the legal defensibility, there may be something that we choose not to comply with, or that we simply cannot at this time comply with it. And that there's a business decision made, but that needs to come from the legal advice that we can retain from outside counsel that says, okay, here's how it's worked for other people. Here's what you can and can't do. This is not going to fly. This might work. You're probably going to still pay these penalties, but you could argue this mitigating circumstance, right? Like that's where, as an attorney, you would need that full complex of information to help render situational advice that then the business decides on.
That's right. It's the analytical part. It's the analysis that goes into this. So using your example, look, probably the most frequently asked question I get when I'm working on the risk management side from businesses is, how do we prioritize what we do? We can't do everything. We can't fix every problem. How do we prioritize? And then I put on my hat of going back and looking at all the breaches I've handled, looking at all the security assessments I've worked on, and say, look, based upon my experience, where companies get the most problems and liability and regulatory enforcement actions are when they don't do these kind of things. So let's put those at the top of the list. The things that regulators aren't expecting yet, sophisticated artificial intelligence endpoint solutions, they're not expecting everybody to do that yet. But are they expecting you to have decent password policies, and talk about social engineering? Yeah, we're expecting that. Let's put those up higher. That kind of analysis is the kind of thing you can protect. And that's what can be most valuable sometimes when you're going through that why didn't you do XYZ type of rehashing. But then again, sometimes the most important thing you as a business can do whenever you have had a problem is say, look, I didn't do X, Y, and Z, and here's why I didn't. And so while we may technically have that privileged information, it may be in our best interest to show that to the Securities and Exchange Commission, because if they open an investigation on you and then you start claiming privilege, they're going to immediately put it straight into the enforcement action against you.
Yeah, they're going to get a little bit more excited about it. No, and
exactly.
I mean, I'm loving this topic, and so we'll wrap it up with this. I mean, and you said this to me in our prep, but in terms of what it all means, I'll sum it up with: if you think you need this, you've got to remember you're seeking legal advice. Counsel could be interpretations and insight and experience. In fact, ideally, that's what you're trying to get, and you can certainly act as if you were doing something that may be privileged. But it's not a blanket assertion that you make. It's ultimately a decision by the courts. So also be prepared that anything you do may not actually be privileged, and you'll probably put yourself in better stead, which means, the more importance it has, the more likely it should be said. I guess that's why we see people meet on park benches in the TV shows as they stroll up to each other in overcoats in the middle of August or however that works out. But basically, it's that there's merit in. Some things are better left as discussions. Some things are better left said quietly in person. And, if it's not, it might be privileged. It might not. No harm in trying if your intentions are good. But if they're not, you're probably just wasting the court's time and your money.
Exactly, Michael. A phone call is better than an email. And sitting on the park bench or walking down to someone's office is better than a phone call when it comes to information that you don't want out there. And tell your people in the beginning, before you ever have an incident, control your communications. I don't want to ever see, why the hell didn't you fix this? We've talked about it for years. Put in an email. If that's how you feel, come down and talk about it.
All right, it's gonna be interesting. Listen, Shawn, I'm certain people are gonna have questions. At Shawn E. Tuma, I'm at Catalyst. We're both on Twitter. You can hit us up there. You can send either of his emails, or you can reach out to me any other way that you're comfortable. And Shawn, if there's any more questions on this, we're gonna follow up. It's always a treat for me. I enjoy our conversations. I learn more, as you can imagine. My brain is popping now, so I look forward to our next in-person place. Where can people find you coming up if they want more, or they want to see more of the awesome places that you are? I mean, you're all over radio and TV these days, but where should people look?
Yeah, that's a great question, Michael. I need to put a place on my blog for upcoming events. I'm doing one or two this week, but they're private events. God, I can't even think right now over the next couple of weeks. All right,
I'll make sure we put your blog in the show notes, but give us real quick, what's your blog?
Yeah, it's www.shawnetuma.com, ShawnEtuma.com.
Perfect. Solid. Shawn, thanks for joining us for Business Security Weekly. Stepping in for Paul. Shawn's going to drop off because we're going through 16 updates. This is going to be rapid fast, and we have exceeded the limit on our credit card for legal billing for the month. So, Shawn, thanks so much for joining us, and we'll look forward to having you come back. It's going to be a good time. We're going to take a quick break. You can go to facebook.com/securityweekly. Give us a like, because that helps us and we feel validated and better. It lets you ask questions, get engaged with us, see what's coming up, all the great stuff happening across the whole network. When we come back, 16 updates in a short segment, including the 5 exits.